Hi, good morning, everybody. It is 9:01, and I see that we have participants coming in and clicking in, but I wanted to go ahead and get started with our 13th Annual Fiduciary Focus. I can't believe we've had 13 of these. This is our second one that is virtual. My name is Christine Piersall, and I am the chair of the Estate Planning Private Client and Fiduciary Services practice here at Williams Mullen. I am based in our Norfolk and our Virginia Beach offices here in Hampton Roads. I'm so excited about our program and to be joined by my colleagues, Farhad Aghdami, Kevin Bender, Tammy Calabrese, Jenny Connors, Dan Durst, Jim Head, and Ben Pace. We've got an excellent program like we normally do, and I'm excited to bring the content, although remotely, and said it last year, I hope we're in person again, but maybe next year we will be. So before we get started, I want to get done with a few of our housekeeping items because we are virtual again, and it's hard to raise your hands. So at any point during the presentation, you can submit questions by using the Q&A button at the bottom of the screen. Our panelists or our speakers will address them as time permits. If for some reason we do not get to your question during our webinar, we will follow up with you individually. Also, if you're having any audio or technical problems, please use that same Q&A button, and our great team that's helping us, that's more technologically savvy than we are, will help you resolve them. More importantly, continuing education. I mean, I know you love hearing from us, but we do get you credits. We are approved for 3 hours of CPE credit. We're pending approval of 3 hours of CFP credits and pending 3 hours of CTFA credits. By Monday afternoon, you will receive an email with a copy of the presentation materials, a recording of today's webinar, and information about claiming your continuing education credits. The email will say thank you for attending, so don't think it's spam and delete it. Just keep an eye out for this email. And if you don't see it by Monday afternoon, please check your spam filter. On today's presentation, some of our speakers will be using the polling feature. We hope you will enjoy the interaction with us, and we look forward to your answers. And heads up, if you're using multiple monitors, the polling may appear on a different monitor than where your where your Zoom window is displayed, and it's just going to pop up. So be on the lookout for that. All right, so on to today's agenda. And why you guys are here, other than getting your credits, of course. We'll be giving you guys some great content today. We're going to start off with recent developments affecting fiduciaries, presented by 3 of our excellent speakers, Tammy, Dan, and Ben. And then a panel discussion with planning with unique assets. We've got a great group of panelists. I'm on it. I'm a little biased, but Farhad, Kevin, Jenny, and Jim Head. We are all going to be speaking of very different assets and just, discussing planning with those assets, and that's going to be great. And then after that, we'll take a short break because we all get Zoom fatigue. And then our final program is it truly irrevocable, modifying or terminating an irrevocable trust? So without further ado, I will pass it off to Tammy, Dan, and Ben for our first program.
Thanks, Christine. Good morning, everyone. I'm Tammy Calabrese. I'm a partner here at Williams Mullen in the Tyson's office in the Private Client Fiduciary Services Group. And I will be starting off this morning discussing recent federal updates. Despite the various proposals to lower federal transfer tax exemptions and increase the tax rates, none of them were enacted in 2021. While it's possible that some of these proposals could still be enacted in 2022, they are now moot. Currently, the estate tax exemption is not set to revert until after 2025, when the Tax Cuts and Jobs Act expires. At that time, the exemption is to go back to pre-2018 levels, closer to $5 million and some change. However, in the meantime, this new year brings us new estate and gift tax exemptions, giving our clients the opportunity to continue to lock in rates and exemptions through a variety of estate planning techniques. The applicable exclusion amount and the GST exemption amount for 2022 is increased to $12,060,000 for individuals, $12,120,000 for married couples. The gift tax annual exclusion went up 1,000 to 16. Annual exclusion for gifts made to a non-US citizen spouse, $164,000. The dollar amount for determining the favorable 2% portion of tax deferred under a Section 6166 election is up to $1,640,000. The dollar amount limitation for the special use valuation reduction under Section 2032A for certain farm and other qualified real property is $1,230,000. Next slide. Thanks. The top income tax bracket for trusts and estates in 2022 is 37%, and this will kick in after taxable income exceeds $13,450,000. One note here is that trust will reach the 37% tax bracket quickly. So a 663B election to carry out the trust income to the beneficiaries will likely allow the trust to realize significant tax savings due to the difference in the trust and individual income tax brackets. And we can have our next slide. Thank you. There have been there's been a lot of clarification in the final regs over the past couple of years due to provisions that were enacted by the Tax Cuts and Jobs Act with respect to deductions for estates and trusts. The Tax Cuts and Jobs Act suspended all miscellaneous itemized deductions under Section 67 for individuals, estates, and non-grantor trusts beginning after 2017, so for tax years 2018 through 2025, under a new provision 67G. However, this new provision did not clarify whether deductions for estate and trust administration expenses under 67E were also prohibited by the suspension. The final regs issued in October 2020 clarified that deductions allowed to an estate or non-grantor trust are not miscellaneous itemized deductions under Section 67E and are not subject to the 2% floor in calculating adjusted gross income. One of these deductions, one of these allowable deductions, are costs paid or incurred in connection with the administration of an estate or trust that would not have otherwise been incurred had the property not been held in the estate or trust. Okay, next slide. We're going to take our first poll this morning. Okay, which of the following expenses would be considered to have been incurred in connection with the administration of an estate or trust? Okay, we'll have a couple more seconds here. Let everybody get a chance to vote. Okay, that's great. We've got about 80 people who voted. Okay, so A, B, and D are all expenses that would be considered to have been incurred in connection with the administration of an estate or trust. Unfortunately, trustees' lunch costs do not fall under that category. Thank you for everyone participating. Other permissible deductions under Section 67E include a personal exemption deduction for the estate or trust under 642B, or distribution deductions for trust either distributing current income or accumulating income, and under sections 651 and 661. All right, can we get this polling? Sorry, I'm going to try to get this off the screen. There we go. Okay. The 2020 final regulations also provided some guidance as to the excess deductions allowable under 642H to beneficiaries succeeding to the property of an estate or trust. By way of background, 642H provides that if on the termination of an estate or trust, the estate or trust has for its last taxable year certain deductions in excess of gross income, those excess deductions are allowed as items of deduction to the beneficiaries succeeding to the property of that estate or trust. The final regs provided some guidance as to the character, the amount, and the timing of those excess deductions. With respect to the character, the final regs clarify that the character of the excess deductions do not change when succeeded to by the beneficiary, but rather retain in the hands of the beneficiary the same character while at the estate or trust level. So if an excess item of deduction passes out to the beneficiary and it was a miscellaneous itemized deduction while in the trust, it will then also be a miscellaneous itemized deduction for purposes of the beneficiary. The final regs also provide that an item of deduction succeeded to by the beneficiary remains subject to any applicable limitation under the code with respect to the beneficiary computing its own tax liability. And the fiduciary is also required to separately identify on Form 1041 and Schedule K1 all deductions that may be limited when claimed by that beneficiary. Finally, the regulations provide that excess deductions are allowable in the taxable year of the beneficiary in which the estate or trust terminates. So excess deductions of a terminated estate or trust cannot be carried forward to a subsequent year of the beneficiary. We have the next slide. Thank you. Another deduction in which the final regs provided us some guidance was with respect to the Section 199A deduction. Section 199A provides a deduction to trusts and estates of up to 20% of qualified business income from a U.S. trade or business operated through the trust or estate. The final regs clarified that in determining taxable income and otherwise computing its Section 199A deduction, a trust or estate described in Section 663C with substantially separate and independent shares from multiple beneficiaries will be treated as a single trust or estate. With respect to allocating any of the 199A deduction, the regs clarify that the trust or estate will be then treated as separate and independent shares for purposes of allocation, but the computation of the actual deduction to see if the trust qualifies, the trust will be treated or the estate as a single entity. Finally, the final regs provide that with respect to any taxable recipient of a unit trust or annuity amount coming from a charitable remainder trust has to take into account those annuity or unit trust amounts received from the trust in calculating the recipient's own Section 199A deduction. Okay, well, that is it for me on, oh, excuse me, no, it's not, sorry. I didn't realize we have one more section. Okay, our last poll for this segment, an estate or trust must file an application in order to get an extension of time to file Form 1041, true or false? Okay, looks like everyone's had a chance to participate. Thank you. The answer is true. However, we have now gotten an automatic extension of time at 5.5 months for an estate or trust to file a Form 1041 once that application has been filed. We can go to the next slide, please. Great. Final regulations provide in a state or trust that's required to file 1041 an automatic 5.5 month extension once that application is in fact submitted. IRS has also extended through its temporary approval of accepting electronic and digital signatures on estate and gift tax returns, and we have that extension through October 31, 2023. And we've got a new $67 user fee, which will apply to any closing letter for federal estate tax return, any estate that's requesting a closing letter for its federal estate tax return beginning October 28, 2021, and that user fee must be paid using pay.gov. The IRS still gives the option for an estate to obtain a transcript free of charge, as opposed to requesting the estate closing letter. Okay, now that is all that I have for federal updates. So I'm going to turn it over to Dan, who's going to be talking about recent Virginia updates. Thank you.
All right, thank you, Tammy. So in the next 15 minutes or so, you're going to hear about bills of interest that came up in last year's legislative session and that are being considered right now this year. And you'll hopefully get a few practical ideas or tips and have a view into what is coming or might be coming down the pipe. So now I'm going to cover several bills relatively quickly. If you are interested in tracking any of these bills or others on your own, go ahead and go to the next slide. Then you should go to the Legislative Information System website. It's found at lis.virginia.gov. Just go there. There's a link to bills and type in the bill number for a complete history of the bill that you're looking for. So let's look at a couple of the bills from last year. Go to the next slide. This is House Bill 2230 about supported decision making. This law, it became a law on March 18th of last year. The law creates a new kind of arrangement for adults with intellectual or developmental disabilities to receive assistance managing their affairs. Under a guardianship, you have a guardian or conservator who acts for a ward. Under a power of attorney, you have an agent or an attorney in fact who acts for the principal. And under this new law, the disabled adult is the principal, and the principal can enter into a supported decision-making agreement with a supporter. This is much less restrictive than a guardianship, in which a ward is declared incompetent by a court and loses the power to do certain things for themselves. We can go to the next slide. And it's not the same as a power of attorney because the supporter doesn't have the authority to act for the principal like an agent does. It's a new, different sort of arrangement, which you might be seeing more of in the future. And the thing to keep in mind is that the supporter is there to help the principal manage, understand, communicate, and so on, but the principal still needs to make the decisions to sign any documents that you need signed, and so on. We can go on to the next slide. The next bill of interest from last year, or bills, were Senate Bill 1435 and House Bill 1856. And they were the same text, but they were brought by legislators in both the Senate and the House on parallel tracks. Ultimately, both of these bills were defeated at the Senate committee level, and the bills would have made a number of changes relating to electronic wills and other estate planning documents. Let's go ahead and go to the next slide. As a historical note, these bills were proposed by the Virginia Bar Association in response to requests from legislators to have bills to offer that would make it possible to execute estate planning documents remotely. I had the opportunity to be on the drafting committee for the bill, and recall that the 2021 legislative session was the first one since the beginning of the coronavirus pandemic. At the start of the pandemic, there were a lot of people in industries pushing for ways to execute documents remotely. At the most basic level, the bills would have made possible electronic remote execution of wills, trust agreements, and advanced medical directives. Currently, wills and advanced medical directives, which generally require witnesses for proper execution, cannot be executed remotely. The witnesses must be physically present, and there is a potential ambiguity in the trust code that makes it less than perfectly clear that a trust agreement can be signed electronically. The bill also would have created a new statute to recognize electronic wills, or wills that are executed in a purely electronic format, no paper required. When drafting the bill, we struggled with a number of issues to try to strike a good balance between flexibility and preventing fraud or unnecessary confusion. We found out in the process that electronic notarization can be very, very secure. So we provided in the draft bill that all electronic wills must be self-proven, meaning sworn to by the testator and witnesses at the time of execution before an electronic notary public. We also took different paths from the Uniform Electronic Wills Act with respect to revoking an electronic will and how to probate an electronic will. As some of you probably know, I'd be happy to talk your ear off about electronic wills if you have any questions. The last thing that the bill was going to do, and perhaps the most consequential thing from your viewpoints, was to validate wills signed in other jurisdictions. Many people don't realize or appreciate that if someone moves here to Virginia from another state with a will, that will is going to be valid if it satisfies Virginia's requirements for making a will. Generally, that means that it must be in writing, signed by the testator, and witnessed before two physically present witnesses. For the last 100 or 200 years, the many states' laws have been very similar with respect to those three requirements. Now, however, you have 10 states, so those are the green states here on this map, and more coming, I'm sure, that allow electronic wills. And most allow remote electronic execution. Most of these green states on the map. Some allow electronic execution before a notary without any other witnesses. It's going to be important to find out whether, if a client has made a will in another state, was the will tangible or was it electronic? And if it was it witnessed or not? And if so, whether the witnesses were physically present or were they remote? By the way, on this map, those yellow states are states where electronic will statutes are currently proposed. If a living person comes to Virginia with an electronic will, the conservative advice should be to redo that will on paper. Ultimately, last year, some of the senators' concerns regarding potential fraud and elder abuse with electronic wills outweighed the arguments in favor, and the bills were defeated. Perhaps when electronic wills gain more traction nationally, we'll see this bill or a similar one resurrected. So this is where I get to ask my first polling question. Have any of you encountered an electronic will yet? We're having great participation this morning. Thank you for that. It looks like we're slowing down on the responses, so we can go ahead and close the poll and share the results. So a few of you have seen electronic wills. That's fascinating. And if it's something that people are willing to talk about, I'm sure others would love to hear it, but it at least will make good cocktail conversation, I'm sure. So let's go on to the next bill of interest in the current legislative session. These are the things that are happening right now. So the next slide, House Bill 370. It proposes to replace the current Uniform Principal and Income Act with the new Uniform Fiduciary Income and Principal Act. The first change is the name. The old acronym was UPIA or UPIA, and it's easily confused with the Uniform Prudent Investor Act, which is also UPIA. So the new acronym is UFIPA, and a good law, of course, requires a good acronym. As I'm sure you all know, and as many of you have experienced much more closely than me, the Principal and Income Acts are very practical laws telling you how to allocate distributions, receipts, and expenses between income and principal, which can make a tremendous difference to beneficiaries of trusts and estates. Sometimes a beneficiary is entitled to income and no principal, or perhaps some portion of principal. And at those times especially, it's critical to know what is allocated to income versus principal. On the other hand, sometimes the best investment strategy for an estate or trust isn't the one that has to focus on whether it's going to generate an impartial amount of income or principal for an estate's or trust beneficiaries. Let's go ahead and go to the next slide. The biggest changes with the new act, the UFIPA, would make it easier to adjust between income and principal and allow more options for converting to or modifying a unit trust. Under the UFIPA, the fiduciary generally would be allowed to adjust between income and principal if it would assist the fiduciary to administer the trust or estate impartially. That's the test. If it would assist the fiduciary to administer the trust or estate impartially. Under the current law, the adjustment isn't allowed unless it is impossible to administer the trust impartially. So it's a much easier standard to satisfy. But the UFIPA makes it clear that the fiduciary is not under a duty to make adjustments. As for unit trust, the UFIPA allows more ways of calculating the percentage to be distributed. Under current law, a trust converted to a unit trust must distribute 3 to 5% annually. For tax reasons, it might still make sense to keep the unit trust distribution rate at 3 to 5%. But in other cases under the UFIPA, the interest can be any percentage, the rate can be variable, the unit trust percentage calculation can be done in periods other than whole years, and so on. So in other words, there's a lot more flexibility to allow a solution that will best allow the fiduciary to invest assets for the best return and also to treat the beneficiaries impartially. Let's go to the next slide. The next bill is Senate Bill 554, so 554. It's a repeat of an identical bill brought last year, and that was actually proposed 2 years ago as well. It was opposed by the Bar Association, defeated last year. But the fact it's making a second appearance makes it worth mentioning. And by the way, most recently, it does look like this is going to pass, and it may be amended again before it passes, but there's a good chance that it won't be. That's the most recent news. And I did update all this stuff as of 2 days ago, but there's a committee hearing on this particular bill today, and it looks as though it will pass. Ultimately, the senator sponsoring this bill is concerned about bad folks unduly influencing people to make wills that don't reflect their true wishes. He thinks it's too difficult under the current law to prove undue influence. So he proposes changing the law to make it easier to prove undue influence, which would overturn or invalidate the will. Effectively, he would make the change by requiring the proponent of the will, after certain minimum facts were shown to suggest undue influence, the proponent would have to then prove that the testator was not unduly influenced. Proving that undue influence was not present might be a hard thing to do, especially in your typical innocent will drafting and execution situation. As a result, this change would certainly catch plenty of good wills in its net and overturn them. Of particular concern to us are situations with maybe a child who's a caretaker, who's given a home or something disproportionate to the other children, or maybe even a second spouse where the estate plan has changed to benefit the second spouse more than in a previous plan. So as with most laws, it's a question of where or how to strike the right balance between flexibility and the freedom to act versus protecting against abuses. And this bill would dramatically change that balance. So this is something to keep your eye on if you're administering a will and have a situation where a will has been changed and contrary to a prior will. There's a greater chance that people will challenge wills for being unduly influenced. Let's go to the next slide. We can go to the next one after this too. House Bill 693. This next bill has got to be the most technical, boring legislative update of this bunch that I've picked, but I include it because I think it's right up our alley for a fiduciary focus. This bill basically would make it clear or make it possible, depending on your opinion of the current law, that a vehicle titled in a revocable trust is not subject to a property tax on business vehicles. We can go to the next slide. When I saw this bill, I was surprised to hear that some practitioners routinely advise their clients to go to the DMV and retitle their cars into revocable trusts. Evidently, when their clients have done that, the DMV checks a box that indicates that the car is held in a business because the DMV doesn't have a personal box for a revocable trust. So then the client's surprised when they receive a larger personal property tax bill because their car doesn't qualify for non-business tax relief. We haven't historically, here at Williams Mullen, I think, recommended to clients that they retitle their cars into their revocable trust. So I haven't seen this problem firsthand. But in any event, this bill looks like it's headed toward enactment, which will make it easier to put cars into revocable trusts without negative property tax consequences. So now I get to ask my second polling question. How many of you have seen a trust holding title to somebody's personal vehicle in Virginia? I'm curious to know if this is how routine or ordinary this is, this advice. Again, thank you all so much for your participation. I think it makes it more interesting for everybody. All right, we're slowing down, so we can go ahead and close the poll and share the results. And I mean, obviously a majority have not seen this, but there's a significant minority who has. So apparently there are people out there doing this, and this new law should reduce the personal property tax problems that they might be encountering. So I'll go ahead and close the poll. House Bill 1237 is next. This bill clarifies that a law firm can be a trustee. So I've actually had a couple of banks in the last couple of years ask me to point out the statutory authority. When I say banks, I mean sort of their legal department. They asked me to point out the statutory authority of a law firm to serve as a trustee, and hopefully this bill will make the situation more clear. Banks and trust companies derive their power to serve as trustee under the banking or financial institution statutes. And those statutes govern entities that are engaged in trust business. This bill clarifies that lawyers and law firms acting as fiduciaries are not engaged in trust business, and so they're not governed by the banking statutes. Instead, law firms are authorized under the professional corporations or professional LLC corporation, the professional LLC statutes, to serve as executors, trustees, or other fiduciaries as part of the practice of law rather than as trust business. So we can go to the next slide. And one more. The last bill I'll mention today is Senate Bill 124. Virginia already has a criminal law punishing anyone who takes financial advantage of a mentally incapacitated person. Senate Bill 124 would create a new separate crime in addition to the one already on the books. The new crime would punish an agent who takes financial advantage of an incapacitated principal. Basically, if you are an agent under a power of attorney and you steal from the principal, the legislature thinks you're an extra bad person. So you get charged with another crime, which makes it just a little bit riskier to accept the job of being an agent under a power of attorney. So we can go to the next slide. That is my last bill that I wanted to summarize for y'all today. And at the end of our program, I'd be happy to answer any questions any of you might have. So now I'll go ahead and turn the time over for the rest of this session to Ben Pace.
Thanks, Dan. I always look forward to being able to provide this group with updates on the latest developments from case law in Virginia. As many of you know, the Virginia Supreme Court rarely speaks on issues where we want to look up their case law and find some guidance. And so when we do see significant cases that address issues we see fairly often, it's important, and it's something I think we should all pay attention to. Again, I'm Ben Pace, a partner in our litigation section here in Richmond. And as a litigator, as I tell you all every year, we get to see the bad side of fiduciary issues when things have gone wrong. And when we see these cases, they can be very instructive to us in how we should address issues in the future. This year, the Virginia Supreme Court issued two significant opinions on in the area of fiduciary matters, and we're going to review both of them. If we could have the next slide, please. The first case involved powers of attorney and the ability of a beneficiary, the daughter of the principal who executed a power of attorney, to obtain an accounting from the agent who happened to be the attorney, in fact, who happened to be her brother and the son of the principal. So while he was competent, the principal in this case executed a durable power of attorney in favor of his son. The POA contained a provision that I wish I saw more often in powers of attorney, especially for clients that are the attorneys in fact. It stated that the principal did not want his agent to ever be required to make a disclosure or inspection of the principal's affairs. The actions of the agent, either under this instrument or otherwise, didn't want any disclosures made to any third party about his affairs. It went on to state that the principal authorized his son to refuse any request for disclosure or inspection, and as an expense of the agency, to resist any proceeding to compel such disclosure or inspection. If you're going to accept a power of attorney appointment, in my view, this is a provision that you want. What we see all the time is disputes where the attorney, in fact, has their actions questioned because the family member or the beneficiary isn't happy with what happened to the assets. And And so the disgruntled family member demands accountings, and they use the Virginia Power of Attorney Act and other things to try to obtain an accounting. And that's exactly what happened in this case. The question, when you see a great provision like this in a power of attorney, is to what extent is it going to be enforced in the face of the Virginia Power of Attorney Act and the other mechanisms by which people can seek accountings from attorneys in fact. So if we can go to the next slide. In this case, the son began to manage the principal's affairs after he, and this was a fact of the case, he diminished in capacity and was unable to manage his own affairs. The principal then passed away. His daughter demanded an accounting of the son's actions under the POA and alleged suspicious transactions. Among those were amounts of compensation paid to the son, credit card payments that she questioned, and allegedly some unsecured loans. The son did provide some level of response. With the details weren't in the case about why he provided any response given the language of the POA, but he did provide some level of response. The daughter, of course, was not happy with it, and she filed a complaint against the son, both in his capacity as the power of attorney and as co-executor of the father's estate. She sought both an equitable accounting under Virginia Code 8.01-31 and a statutory accounting under the Virginia Power of Attorney Act, which is at 64.2-1614. The son obviously responded that the POA didn't require him to provide an accounting. They also said that she didn't have the ability to seek an accounting from the executors under 8.01. And their point there was that she was not the personal representative of the estate, so she didn't have standing to ask for an accounting from the executors. The trial court agreed with the son, and by the way, the co-executor, who was a third party, not a relative, was also included in the suit. But the trial court agreed with the son and the other co-executor, granted their demur, and ruled that the daughter had no statutory right to obtain an accounting from the son under the POA, nor did she have standing to seek an equitable accounting from the co-executors. And if we could go to the next slide. Obviously, the daughter appealed to the Virginia Supreme Court. She argued that she had a right to seek an equitable accounting on behalf of her deceased father because the co-executors in this circumstance would not investigate the son's suspicious transactions because the son was also a co-executor. For those of you that attended last year, you may recall one of the cases we reviewed there where the plaintiffs in a case to rescind some deeds were unhappy and they said they had standing to bring the lawsuits because the personal representative was somebody who benefited from one of the deeds. You may recall that case. Here, the daughter made a very similar argument. I have the right to seek this accounting on behalf of my deceased father because the co-executor, who's refusing to provide the accounting, took part in the quote unquote suspicious transactions. She also felt she had a right to seek an equitable accounting of the co-executors because she was a beneficiary of the estate, which I think most of us know is accurate. A beneficiary of an estate is someone who has the right to seek an accounting from fiduciaries. Finally, she asserted that the Virginia Power of Attorney Act permits her, as a relative and beneficiary of the principal, to seek a statutory accounting because in this instance, she had a good faith belief that the principal was incapacitated. And in fact, in reading the case, it looks like, they agreed he lacked capacity, at least to the extent that he couldn't manage his own affairs when the principal was when the agent was taking these actions. Many of you may be familiar with the Power of Attorney Act's provision that says a relative of a principal can seek an accounting. A relative is somebody who has standing to seek an accounting where they have a good faith belief that the principal was incapacitated at the time the agent took the actions. We see this provision invoked all the time. Again, it's not something that as a litigator defending an attorney, in fact, that we like very much, because a lot of times folks are just disgruntled and they want to go on a fishing expedition and they want to harass the person who held the power of attorney to seek to gain an advantage or leverage in how assets are going to be distributed or handled. And they just say, well, the principal was incapacitated, so I get an accounting and I get to look at every check and review every account statement and question everything. And it can be something that makes it very difficult on a power of attorney when that situation arises. So that statute is out there. And this is our first poll question. How did the Supreme Court rule? Was the daughter entitled to an accounting under any of her theories, an equitable accounting from the executors, an accounting of the power of attorney under the statute? Go ahead and answer, and we'll see what everybody thought. Looks like the votes are coming in. Give you just a few more seconds and then we'll close it. If you haven't gotten your vote in, go ahead and do it now. A few stragglers. All right, I think we've got everybody. So we'll end the poll and look at the results. Very interesting, 75% felt the daughter was entitled to some form of an accounting. The other 25% felt that the daughter was not entitled to an accounting. If we can go to the next slide, we can give you the answer. All right, I got to close my poll. So the minority was correct here. The Supreme Court affirmed the trial court's ruling that the daughter had no right to an accounting. And this is a Justice Kelsey opinion, and he's been very active in the last several years on trust and estate issues affecting fiduciaries. And where he has come down is a very traditional, structured view of the court's ability to oversee estates. So regarding the daughter's claim for an equitable accounting, the court held that the son was not the daughter's agent, had no fiduciary duty to the daughter. So on that front, she had no right to an accounting. That was easy and made a lot of sense. While an equitable accounting claim survives the death of the principal, the personal representative, not a beneficiary of the estate, is the proper party to litigate on behalf of the estate. This was the same ruling we had last year in the case we discussed. It was the Griffith case. Some of you may recall it. Again, that was Justice Kelsey, and he's reiterated that only under very rare special circumstances will a beneficiary be able to seek a claim that has survived the death of the principal on behalf of the estate. Typically, and almost always, it's the personal representative, not the beneficiary, that has standing to litigate on behalf of the estate and to pursue a claim of the decedent that has survived his or her death. Claims of suspicious transactions is not going to be enough to amount to the special circumstances where a beneficiary is going to be entitled to sue on behalf of an estate. If we could go to the next slide. Another significant part of this ruling, and it's a really thorough and interesting opinion that goes into a lot of detail about the history of accountings, as you typically see with Justice Kelsey. But the court held that one of the interesting parts of the ruling was that while a beneficiary might have a right to an accounting from executors, the daughter did not have a right to seek an equitable accounting where the estate was subject to the probate court's oversight through the Commissioner of Accounts and the related statutory process. In other words, the equitable accounting is an equitable remedy for an accounting, but she already had a legal remedy via the court's typical Commissioner of Accounts oversight of estate accountings and that process. She has a right to receive the accountings that are filed with the Commissioner of Accounts. She's, as a beneficiary, we kept updated and provided notices about those issues. She has the ability to object to accountings. She has the ability to make claims through the Commissioner of Accounts process. She can file a suit to surcharge and falsify any of the accountings filed by the co-executors. And that, I believe it's within 10 years of the filing of the accounting, so she has plenty of time to do it. Long story short, Justice Kelsey, once again, has said, we are going to honor the circuit court and their ability to oversee estates, and we're not going to let beneficiaries disrupt that process when we already have in place a very structured statutory process. Regarding the claim for a statutory accounting under the Virginia Power of Attorney Act, the court held that the POA Act's provision does provide relatives such as the daughter with the ability to seek an accounting, but it also specifically granted principals the right to prevent such accountings, even in the case of incapacity. Both of the Power of Attorney Act sections that discuss a relative getting an accounting are prefaced with the caveat that they get the accounting except as otherwise provided in the power of attorney. I'll also mention that while Justice Kelsey said, look, we're going to honor principals when they have capacity and they put in their power of attorney that they don't want anybody to be able to get an accounting, we're going to honor that. But they also, he also pointed out that you have to file the suit within a year of the death of the principal, and the daughter had failed to do that here as well. So that would have been an additional reason you have to file it within a year of the death. If we could go to the next slide. The court did provide a good summary of its interpretation. The underlying theme of all these provisions is that courts should respect the personal financial privacy of competent principals, while at the same time providing opportunities for others to initiate account rendering litigation on behalf of incompetent or deceased principals. That said, the court made it clear here that if the principal provides strong language like the provision in this power of attorney that forbids others from holding his agent to account, those are going to be honored by Virginia courts. And I've provided the case Phillips v. Rohrbaugh and the citation there if anybody wants to look it up. One thing I do want to point out is that you may be thinking, well, what remedy does this daughter have in the face of this opinion? There is a remedy, and Justice Kelsey discussed it in the Griffith case last year. If the principal really was incapacitated and actions really were taken by the son to take advantage of it, and the executors refused to pursue that claim when presented with the evidence of those issues, the daughter can move to remove the executors. She can petition the court to remove the executors who refuse to pursue such claims. And if she can convince the trial court, again, the court that, as Justice Kelsey refers to the trial court in these situations, the chancellor, if the probate court chancellor, and I like this language because it reminds me of Judge Lamb's treatise that I was trained on by Bob Iker, if any of y'all remember Bob Iker, who was a much better fiduciary litigator than me. But the chancellor is kind of a gatekeeper here. And if he hears the evidence and decides that these executors should be removed because they won't pursue these claims, then we're going to honor that. But we're also going to trust that chancellor to not burden an estate with unnecessary litigation. And we're going to leave those executors in place if we don't think there's enough smoke there to say it's a fire. So moving to the next slide, in our second significant case of the year, speaking of petitions to remove executors, this is another scenario we see all the time. Siblings who can't get along serving as co-executors or co-trustees. It happens way too often. I guess parents are always just unreasonably optimistic that their children will get along and cooperate in the administration of estates. I don't know what the answer is. Maybe it's just make one of the siblings the fiduciary to try to eliminate the fighting. But whoever you pick is going to be attacked down the road if there's not good harmony within the family. But it really can do harm to an estate or trust when you have that situation. The second case is right along those lines. In this case, the testator died and left a significant estate to her 3 sons. 2 of these sons were appointed co-executors of the estate. And the typical tragic story occurred. They had all kinds of disputes. Several law firms and accounting firms resigned because they couldn't work with the co-executors. The situation was described as them being hopelessly deadlocked. One of them hired their own lawyers and filed a petition for removal. The other co-executor hired his own set of attorneys, filed a cross petition for the removal of the other executor. And they both went to court alleging different breaches of fiduciary duty by the other, where they took action on estate assets. Allegedly, they did it unilaterally for their own benefit. And they had a trial where basically the brothers each presented a case saying, I'm right, my brother's wrong, and you should remove him and let me do what I want with the estate. After a bench trial, the trial court removed both brothers as co-executors and appointed a disinterested third party, a commissioner of accounts, as administrator of the estate. This is, to me, a very bold action by the trial court. My guess is neither of the, and I didn't specifically say in the case, but I can't imagine either of the brothers in their petitions asked the court to appoint a disinterested third party. Seems to me the court fashioned this remedy after seeing the presentation of the 2 brothers and throwing his hands up. But one of the other significant parts of this decision, of the trial court's decision, was that he refused to award the brothers their attorney's fees or any compensation for their work as executors. We go to the next slide. Each of the brothers appealed. They asserted that the trial court abused its discretion, committed a clear error of judgment in removing him as executor. Each of them alleged that the trial court denied and denying attorney's fees when they were acting in good faith and in the interest of the estate. And they alleged that they erred in denying any fiduciary compensation. Now, again, the trial court didn't reimburse them for any of their attorney's fees, and he did grant them what they wanted, removal of executors, which he said was in the best interest of the estate. And he didn't provide any compensation to them at all. So this is our next set of poll questions, and I think they'll both come up at the same time. But did the trial court err in removing both brothers? Should the trial court have left one of the brothers in? And should either brother have been awarded any attorney's fees or any compensation? So I see you've started voting. We'll let it go for just a minute or so if everybody could get their votes in. Okay, a few still coming in. We'll let it go for just a second or 2 more. All right, I think we are at the end here. The trial court did not err. They should have removed both brothers, 85%. And should they have been awarded attorney's fees? No, 69%. Yes, 31%, which I think is interesting. And I'll discuss in a minute why I like where the 31% is coming from. Okay, if we could go to the next slide, we'll give you the answers. The Supreme Court agreed. The trial court did not err in removing both brothers. As you could tell from my brief presentation, and as the trial court obviously felt, the Supreme Court agreed with them. These brothers couldn't get along, and the best thing for the estate was to remove both of them. The important things to remember here is the trial court is afforded considerable latitude when faced with the decision of whether to remove an executor. It's an abuse of discretion standard, which means it's going to be very difficult to overturn. It would have to be a clear error of judgment. And the court held that where you have significant friction between co-fiduciaries, leaving them hopelessly deadlocked, that's going to be sufficient grounds for removal of both of the fiduciaries. So if we go to the next slide, the brothers were not entitled to an award of attorney's fees or fiduciary compensation. Again, the Supreme Court affirmed the trial court and emphasized that for a fiduciary's attorney's fees and costs to be reimbursed, they must be for services that aid the executor in the performance of his duties and are beneficial to the estate. Such fees cannot be reimbursed if incurred for the executor's personal benefit. This is the part where I agree with the 31% a little bit. Now, I don't know if it was argued at the trial court or on appeal, but I would argue that some of the fees had to help the estate because it got the executors removed without the filing of the initial petition for removal of the co-executor. The court might not have reviewed these issues. The estate might have languished in a deadlock for years. So to some extent, the suit did help the estate, and I think some portion should have been reimbursed. Regarding a commission, any compensation, that is also within the sound discretion of the trial court. An executor is only entitled to a commission when the executor has faithfully discharged his duties to the estate and is based upon the services he has rendered in behalf of the estate. Because the court found that they had at times pursued their own interests rather than the estate's, and that had led to damage to the estate, frustration of its administration, they felt that the trial court was well within its discretion to deny them any compensation. I think this is a little bit extreme. They must have done something that would have entitled them to compensation. But the Supreme, and this was Justice Goodwin, this was his opinion. This is sending a clear message. I know we deal with a lot of clients that are like, well, this is my parents' estate. I can do what I want. I can charge fees to the estate. I can distribute property. And I think this is confirms warnings I've been giving to clients for years. Don't think you can just charge your attorney's fees to the estate or the trust because you think you're right. If there's a dispute, you need to be very careful about that. And also be very careful about what you do. A court reviewing this might say a pox on both your houses. Nobody gets attorney's fees or a commission. I've provided the case site there. If anybody wants to read the case, that's another good opinion by Justice Goodwin. And with that, I'm going to turn it back over to Dan. Obviously happy to answer any questions.
All right, it is 10:05 and we're going to resume our presentation. And I want to thank Dan and Tammy and Ben for an excellent presentation on those recent developments. My name is Farhad Aghdami. I'm a partner in the tax section here and work with the Private Client Fiduciary Services Group also. I'm going to be moderating our next program on planning with unique assets. And what we're going to do is when we send out our copy of the presentation materials by email on Monday afternoon, the slides that cover a lot of the materials that we're talking about today will be included in those materials. But we thought because this is really going to be a panel discussion that we'll just not have the slides, we'll just have the speakers on the screen. And so at this point, I want to talk about kind of tee things up for this presentation, and which is really focused on planning with unique assets. And what we're seeing, I think, with greater frequency is, things that we just haven't seen before in the last 5 or 10 years. Cryptocurrency, qualified small business stock, QSBS, interest in qualified opportunity zones. Retirement plan assets are always sort of a challenging asset class. And then art is becoming something that is really becoming an increasingly valuable asset in our client's estate. So what I'd like to do is kind of go around the horn and talk to each of my colleagues about these assets. And so I think we're going to first kick off talking about qualified opportunity zone funds, QOZs. And I'd like to introduce my partner, Jenny Connors, who's a real expert in our firm on that. And anyway, Jenny, like to share some information with us about QOZs.
Sure thing. So I will start off. Most of the information that we have is the same. And I think most of our participants are probably pretty familiar with OZs at this point. I would say the only change that we do have now is we have passed those 2 hurdle points where you can get some tax forgiveness on your eligible deferred capital gains. So if you'll recall, back in 2019, we had a hurdle date where you could get the full 15% tax forgiveness on your eligible deferred capital gains. That 5% of it was lost at the end of 2019. Now we've passed 2021, so we've lost that remaining 10%. So at this point, we're looking at the benefits of still continued deferral through the later of December 31st, 2026, or an inclusion event, which we will talk about too as well. Or in addition to the deferral that you do get through that period, which right now we're running a little bit under 5 years for that deferral. So that is also a waning benefit. You're also still going to get that tax-free appreciation after a 10-year hold in your qualified opportunity fund interest. So that is still on the table. And because that's really the primary benefit of what people are seeking under OZ rules, we're still seeing a really active market. And I've had a lot of clients who have been really fascinated at how active the OZ market has been. And I will say, even after the end of December 31st, 2021, when I thought it might slow down a little bit, it's still going like gangbusters. And I think the reason is that there's a lot of uncertainty for now various reasons in the stock market. And so you have investors who have not historically invested in real estate and similar projects pumping their deferred capital gains into real estate investments, which are the primary project that we're seeing within the opportunity zone space. So this continues to be a really hot investment. I do think you're seeing the same kind of supply demand issues where you have a lot of people who have these deferred capital gains and are having difficulty finding projects to invest in. But the projects are still ongoing and developers are still putting together and looking for those investments.
So Jenny, let's just do just a very simple example of the benefit. Let's say I sell an asset. Let's say it's pre-IPO stock. I have essentially zero basis in it, and I sell this asset for $10 million. So I've got $10 million of gain. What would you suggest I do to take advantage of the OZ benefit? And maybe just walk through just briefly what benefits there are.
So the benefit on the 10 million, and I guess one of the differences here, this is oftentimes compared to a 1031. One of the benefits of OZ investing is you could take the entire 10 million and invest it in an OZ fund, or you could take part of it. There's no requirement that you invest the whole amount, but obviously you're only going to get OZ benefits on the amount that you invest into a fund that's called a qualified opportunity fund. So if you did opt to put the entire amount into a qualified opportunity fund, you have a certain amount of time to do so. If you're an individual who's selling that stock, you generally speaking have 180 days to make that investment. Once you invest, provided that you continue to hold that investment for over 10 years, any appreciation in your interest in the qualified opportunity fund or its underlying property would be tax-free. So you're only looking at the tax-free appreciation. And the reason for that is the end of the deferral period. When you invest that $10 million, you're only deferring the recognition of gain on that 10 million. At the end of 2026, as of December 31st, 2026, you're going to owe capital gains tax, whether it was short-term or long-term, at that time. So sometime in 2027, when you pay your tax, you're going to pay tax on that $10 million of deferred gain. And again, there used to be some kind of partial reduction in that gain. There was a partial tax forgiveness. At this point, that benefit is gone. So you're going to pay tax on the full 10 million. And importantly, you're going to pay tax on whatever the then capital gains rate is. So if our rates go up Generally, the gain is treated as having been recognized as of December 23rd or December 31st, 2026. So that is one thing to consider when you're planning these investments, is if there's a likelihood of increasing tax rates, you'll pay at the higher tax rate, not at the 2022 tax rate. So then at the end of 2026, you pay your tax on that amount. And if you continue to hold and you meet that 10-year hold, that should be the only tax that you pay on that investment.
Okay, well, that's great. So it seems to me that, on the front end, there's a great benefit, because if I sell the asset, at least I get to defer paying taxes. And I always think paying taxes later than sooner is good. Although, as you noted, it may be at a higher rate. And then I've reinvested into an asset that potentially, if I hold for 10 years, I never have to pay capital gains tax on. And so from a estate planning perspective, that seems like that's a great asset, to be able to potentially give away. It's almost like a Roth, where, you give this asset away and people never pay tax on that in the future. What are there any limitations or issues that if a person, let's say, if I want to transfer an interest in this OZ fund investment, let's say, to a trust for the benefit of my children, or do something interesting from an estate planning perspective, are there any issues that need to be concerned about?
Yeah, so I would say that generally speaking, any transfer of a qualified opportunity fund interest is going to trigger what we call an inclusion event. And there's a few exceptions that I'll talk about, but generally an inclusion event for the holder of that qualified opportunity fund interest has two really negative results. It's going to trigger the deferred gain. So if an inclusion event occurs before December 31st, 2026, it's going to trigger the deferred gain. So Farhad, in your example, that $10 million, all of a sudden you're going to owe tax upon that inclusion event as of that date. And the problem there too is a lot of these inclusion events that can be triggered are what we call dry tax events, where they don't necessarily result in cash. So that would be a really bad result. The other really bad results when it comes to an inclusion event is that it ends your OZ benefits for whatever portion, whether it's all or some portion of that QOF interest, your OZ benefits are gone. So you really want to avoid any kind of transfer that's going to trigger one of these inclusion events. And generally speaking, there are a lot of inclusion events that you wouldn't necessarily think would be inclusion events. So for instance, if you have a transfer incident to divorce, even though Code Section 1041 says that those transfers shouldn't trigger any gain, under the OZ rules, which trump that provision, if you have a transfer of a QOF interest pursuant to divorce, it is an inclusion event and will end those benefits. So that's just one example of sort of these situations that can have some pretty terrible OZ impacts. Another one would be any kind of gift, even if your gift is to a child or if your gift is to charity. Those are all instances that are going to trigger inclusion events and end OZ benefits, and you're all of a sudden going to have a big tax bill.
I think there's an exception for a gift to a grantor trust. I think my understanding under the regulations is that it's really where you change the identity of the taxpayer. So if I was the taxpayer, if I transfer it to a grantor trust, that's okay.
Yes.
But if the grantor trust, let's say, ends during my lifetime, if we turn off the grantor trust status and we create a non-grantor trust, that's an inclusion event. Is that right?
That's correct. So any transfer that under the code, generally speaking, would be a disregarded transfer. So the transfer is a deemed transfer from the holder of the QOF interest to the holder of the QOF interest for tax purposes, whether it's under grantor trust rules or even under income tax rules. Say if you transferred it to a disregarded entity, those transfers are permitted because the ultimate holder of the QOF interest has not changed. Now, if the status of the grantor trust ever changed and it was no longer disregarded or a true grantor trust under the grantor trust rules, you would have an inclusion event. And the only exception there is death. So upon the death of the owner of the grantor trust, that should not be a deemed inclusion event, because under the OZ rules, generally any transfer as a result of death that ultimately winds up in the hands of the beneficiary of the state or the will, that should not be treated as an inclusion event. But any transfer by those recipients upon the death is an inclusion event. So if it ends up in the hands of the holder pursuant to operation of law or by will or under an estate, then that should not be an inclusion event.
Thanks, Jenny. That's really helpful. I mean, I think the one thought I have is my understanding is that if you, for example, if I were to pass away and my interest in the OZ fund went to my estate, that shouldn't be an inclusion event. But the concern is for example, if my estate then transfers it to a trust or to other beneficiaries, particularly if that happens before December 31st, 2026, there's a risk of there being an inclusion event because now the estate is transferring it to another transferee. And so it may be a situation where, frankly, you're going to have to leave the estate open until that date, which, back in 2018 seemed a long ways away. Now it's a little bit closer in time, but it is something that to be aware of. So, Jenny, this is enormously helpful. I really appreciate getting the benefit of your wisdom and guidance. I could talk about this all day, but we've got other topics to cover, and so I'm going to shift gears and talk to my colleague Kevin Bender about Section 1202 and qualified small business stock and some of the planning around that. So, Kevin, can you talk to us a little bit about that and some things that folks should be considering?
Yeah, sure. So Section 1202 provides an exception to the recognition of gain for certain sales of qualified small business stock. And so for those of you who aren't familiar with qualified small business stock, that's a stock in a business that when the stock is issued has less than $50 million of gross assets. And there are some fairly complicated rules about how you compute that, but that's the basic principle. And then so when the stock is issued and you have less than $50 million of assets, it's qualified small business stock. It needs to be a C Corp. So it's only going to be available to C corporations and not S corporations. You see a lot of qualified small business stock sort of in the tech space, especially fintech companies and medical technology companies, there are a lot of them in our sort of geographic footprint here in Virginia, North Carolina. So that's basically what you're going to be looking at if you have qualified small business stock. Importantly, it has to be $50 million of assets at the time of issuance. So that's when the stock is issued. So again, you're talking about a fairly small company. If it later grows to be bigger, that doesn't disqualify the issued stock. But stock that's issued once the company gets really big in terms of its assets won't be qualified small business stock. So if you own qualified small business stock, then when you sell that stock, you can exclude up to $10 million of the capital gain on the stock when it's sold. And that is a per issuer limitation. So the opportunity for folks is that when you transfer that stock by gift or at death, you can what's called stack the 1202 $10 million gain exclusions. So if you gift the stock or the stock is transferred at death, each person who receives stock gets a separate $10 million exclusion. So the limitations there are, it has to be a gift, not for gift and estate tax purposes, but for income tax purposes. What basically that's been interpreted to mean is that the recipient has to be its own taxpayer. So you can make a gift to another individual who's a separate taxpayer or to a non-grantor trust. You cannot make a gift to a grantor trust and get a second $10 million exclusion because that's going to be the same taxpayer. It's going to be under the same taxpayer ID number, or it's the grantor trust is going to K1 all its income to the grantor, and the grantor will pay the tax. So this is not a planning opportunity available for grantor trusts. It's only available for non-grantor trusts. So if you have QSBS, you can set up grantor trusts, make gifts to them up to your $23 million if you're married, or a little over 11 if you're not married, gift tax and estate tax exclusion amount. You can make gifts in excess of that and pay the gift tax, but because of the current rate differential, that probably is not in most cases going to be the most efficient thing to do, but it's an option. The other thing that folks who might own QSBS should be aware of is if you can make the gifts far enough in advance of a liquidity event, you can get valuation discounts that otherwise would typically apply. So we're talking discounts for lack of control, lack of marketability, lack of voting rights, and you can leverage up the gain, right? You can leverage up the amount of exemption you're using to far less than at some point the stock might sell for. So if you're thinking about a liquidity event, a year or more out, or even 6 months out, you should talk to somebody like Farhad, Christine, Dan, and set up some trusts or talk about the opportunities to give the stock away so that you can stack gains. Like you get 10, you can give it to your spouse, that gets 10, trusts keep going more and more and more. So depending on how much you can leverage the valuation discounts, it's possible to exclude potentially $50 or $60 million of gain. And unlike qualified opportunity zones that Jenny talked about, this is just an exclusion of gain. You don't pay tax. It's not just deferral. You don't pay the tax at all. So it's a great opportunity if you have the stock and if you're thinking about the planning opportunities far enough in advance of when that stock might become liquid and be sold.
Kevin, are there situations where the QSBS benefits may be disqualified if you transfer it to, are there disqualifying type transfers that may eliminate the benefit that you're aware of?
There are. There's, generally speaking, you have to be what's called the original recipient of the stock, right? So you can't enter into any transaction with the stock that would be treated as, like a sale, right? You can only gift the stock. What the statute says is that when you gift it, the recipient is treated as receiving it in the original issuance and has your holding period. Whereas if you engage in any kind of transaction that's a sale, that's going to be the event that triggers your non-recognition of gain, and they're not going to have a holding period, or they're not going to have the ability to have been considered having received a stock in the original issuance. It's only gift or death.
Got it. Well, it's an amazing benefit to your point, to not just defer, but to exclude the gain and to be able to stack multiple $10 million exclusions. That's just an enormous planning opportunity. So thank you for sharing that. That's wonderful. I'm going to shift gears now and talk to a partner, Jim Head, who is going to talk about sort of planning with art and the opportunities with art. So Jim, turn things over to you.
Thank you, Farhad. As many of you know, art is one of the best investments you can make. Indeed, over the last 50 years, post-war and contemporary art has on average well outperformed the S&P 500. That's absolutely striking when you think about it. As inflationary pressures mount, as we've seen over the last few months, and equities recede in value, as we've also seen, art is moving to the forefront of investor portfolios. Why? Because it's a relatively stable asset and it generally increases in value. It's also an asset of passion. But what are collectors doing about estate planning for their art? A lot of them aren't doing anything, really. A recent survey conducted by the Fine Art Group found that 81% of collectors plan to leave their collection to their heirs when they pass. Yet, only 57% of collectors have not taken steps to educate their heirs on how to manage, appraise, or sell their collection. Undoubtedly, a smaller percentage of collectors have actually put into place any estate plan for their collection. Well, here are some ideas that you may wish to consider. Basically, 4 options that I have seen. Some collectors may choose to sell their art during their lifetime, but that could be a mistake. You see, there's a 28% capital gain on collectibles, such as art. Another reason that might give one hesitation to sell during one's lifetime is that often art is a highly appreciated asset that was bought many years ago at a much lower cost. So frequently there's a low tax basis. And when the art is sold, perhaps there's substantial gain that will be taxed at 28%. And the donor's family will miss on the step up in basis to fair market value that would otherwise occur upon the death of the donor. Now, some collectors like to gift their art. Gifting art certainly removes the art from the collector's estate for estate tax purposes. However, the collector's family again misses the step up in basis and only has a transferred basis or carryover basis once the art is gifted, meaning that the tax basis in the hands of the donee is exactly as the same as it was in the hands of the donor. Thus, there may be capital gain recognition when the donee later sells the work of art. And again, the tax rate is a whopping 28%. Now, some collectors choose to bequeath their art. With the bequest, the collector's capital gains are virtually eliminated because of the basis step up. But do the collector's heirs really want the art or the money? Yes, they probably want the money. Often, the kids of collectors don't have the same artistic tastes or preferences as their parents and usually just want the cash to purchase other investments. Now, I'd like to provide 4 effective estate planning strategies that I typically recommend for clients who own art. The first is to consider creating an art limited liability company and transfer the art by way of an assignment to the LLC. The owners of the LLC then take back a membership interest. This is perfect for a husband and wife who want to set up an art LLC because each of them would get an undivided 50% interest in the LLC. It permits art to be managed collectively as a whole. It bifurcates the equity interest from the managerial interest, much like a family business. It facilitates gifting of fractional interests if the donor wishes to gift interest during his or her lifetime. And of course, there are possible discounts that may be available for those fractional membership interests or even the undivided membership interest that each spouse owns in the LLC upon their respective deaths. Another estate planning strategy is to gift art to an irrevocable trust. Now, this can remove the art from the estate for estate tax purposes of the donor. However, there's no basis step up. The trust takes the artwork with a carryover transferred basis, much like an individual donee. And there also may be valuation issues. So you have to approach this type of strategy with a bit of caution. You see, you can't put art on your walls and expect that it won't be included in your estate for estate tax purposes, even if you put it into the trust, unless you rent the art from the trust at fair market value. So you have to determine the rental value of the art, which could be difficult because there's no ready market for renting art. That's where a qualified appraiser who is knowledgeable about artwork and renting artwork will be invaluable to determine the rental value. So again, you have to apply some caution when transferring art to an irrevocable trust. And if you put it on your walls, you've got to rent it back if you want to avoid estate tax inclusion. Another strategy that I frequently see is gifting or donating the art to charity. The first step is to see if the intended charity, perhaps a museum, actually wants the art. A lot of times they don't. And if they do, they may want a cash endowment to go with it to pay for conservation, insurance, and exhibition and storage costs. To claim a deduction for gifts and value that exceed $5,000 to a charity, IRS will require an appraisal and a Form 8283, which is a non-cash charitable contribution form. Also, the art must be held for at least a year. So the long-term capital property applies. You should not purchase a work of art with the intention of donating it so you can then take a deduction the same year. It's also important to understand that when gifting art and other collectibles to a charity, the related use rule may jeopardize certain gifts. In other words, to claim a charitable deduction of tangible personal property for fair market value, the donation must be related to the charitable purposes of the charitable donee, such as giving an art to an art museum rather than a hospital, or giving rare and valuable books to a library or historical museum rather than an environmental preservation society. And if the artwork is valued at more than $5,000 and the donor plans to receive an income tax deduction for the full fair market value, the charity must keep the work for at least 3 years. Otherwise, the donor is limited to the lesser of fair market value or the cost basis. That's called the 3-year rule. Another strategy, and I think one that is very important, is to gift art to a donor advised fund. Well, that's how you get around the related use rule and the 3-year rule. You set up a donor advised fund, and then people are donating their art to these donor advised funds. Well, what is a donor advised fund? It's simply a charitable savings account. The donor makes an irrevocable gift to the donor advised fund, and the gift cannot be used for any other purpose than grant making to charities. The donor then gets an immediate tax deduction. The donor and the donor's family members get to then choose the ultimate charitable beneficiaries down the line. The funds can be invested for tax-free growth, and tangible personal property such as art, antiques, and cars can be gifted and to the donor advised fund and then sold by the donor advised fund later. So the donor advised fund is a very powerful charitable giving tool, but just one of many you may wish to consider for clients with artwork and other collectibles. Thank you.
Thanks, Jim. That was terrific. I really appreciate that, and appreciate your participation in this panel. We're gonna shift back to Kevin and talk about cryptocurrency. That is all the rage, and it's something that frankly I don't fully understand. And so I think getting someone a lot younger than me to talk about this, getting Kevin to speak up about it is just great. So Kevin, would love to get your perspective on crypto and particularly the planning issues that planners should be thinking about.
Yeah, thanks for that. And Farhad's right. I went to a networking event a week and a half ago, and the topic was supposed to be something else, and we ended up spending maybe 35 or 40 minutes talking about cryptocurrency. It's very much a hot topic. People don't understand it, and there's a lot of uncertainty about it, both in terms of its value, because I think everybody knows about cryptocurrency is it sort of has wild swings in value every day, but also sort of the tax treatment of it. We're going to mostly talk about this because this is fiduciary focus, we're going to mostly talk about crypto from a gift, estate, and fiduciary perspective. Income taxation of cryptocurrency is a whole other topic. If you're interested in that, I have done presentations on that as well. Basic, 50,000 foot view is it's kind of taxed like a stock, although not 100% the same. The basic principles are fairly similar to the taxation of stocks. Now, for gift and estate tax purposes, cryptocurrency is not a stock or security. So although there's a ready market for it, the sort of typical rules that apply for valuing stock and securities technically don't apply to cryptocurrency for estate gift purposes. You don't necessarily average the high and the low because cryptocurrency doesn't fall within the definition of using the high and the low. Because there is a ready market, the value of cryptocurrency is likely going to be established based on the value on which it's trading on that ready market. But query whether, given the extreme trends, the extreme shifts in value that we see with cryptocurrency, whether if you put it in an LLC or put it in a partnership, could you get valuation discounts? Another issue that you come up with concerning cryptocurrency held in trusts and estates is to access the cryptocurrency, you need a private key. It's just an encryption key. So if you're familiar with computer encryption, it's the same concept. It's very, very, very long. It's a very long number. It's not something you can memorize. And if you lose that key, you can never access the cryptocurrency that's been written to the blockchain, which, in those instances, one, not only do you sort of have a fiduciary problem with accessing the estate assets, which is an essential task of any fiduciary is marshaling the assets, but you also have a question about the value. If you can never get to the currency, what is the value of it? Is it zero? That's never been litigated. And it is, to my knowledge, there's not a letter ruling or revenue ruling about that. So you have these valuation questions about cryptocurrency in estates and trusts that could get very interesting down the road. The other thing, I think, for those of you who actively manage estates and trusts or charitable endowment funds is, to what extent is cryptocurrency investments consistent with the Uniform Prudent Investor Act or UPMIFA, the Uniform Prudent Management of Institutional Funds Act? Now, those acts in Virginia say that there's no asset that's per se prohibited for a fiduciary, but every asset must be looked at as the Act says, sort of in the context of the portfolio as a whole, with an eye towards the risks and benefits of the particular transaction. And both those acts, unless waived in a trust instrument, do obligate the fiduciary to diversify. So, is cryptocurrency a prudent investment? I think there's no perfect answer to that. There was a Virginia Circuit Court case a few years ago. This is not precisely on point, but the principles it elucidates, I think, are about margin trading. That's another high risk kind of activity, typically engaged in by hedge funds and large portfolios with a lot of liquid assets that can bear the margin on risk. So an estate was engaging in a lot of margin trading. They were sued by some of the beneficiaries. The circuit court held that margin trading is not per se imprudent. It was in that particular instance because it amounted to something like 75% of the state's activity. So they failed to kind of diversify and consider risk. But I think the same principles are going to apply to cryptocurrency. I think you can hold cryptocurrency in an estate or trust, especially if you've received it from the decedent, and there's especially there's a waiver, the prudent investor rule, obviously. But if you've received it from the decedent, I think you can hold it. But it shouldn't be a huge percentage of the portfolio, given the risks, right? The extreme volatility of cryptocurrency. It shouldn't constitute a large percentage of a portfolio. I mean, I've talked to some folks who manage charitable funds, and they've said to me they won't hold it, right? They'll accept it. Maybe some will, some won't. But if they accept it, they'll sell it right away. So there's a lot of hesitation, probably rightly so, for holding it, given the volatility and the risks. It's going to become more and more and more a part of people's estates. I've already seen it in 2. So it's out there. People are going to own it. It's going to, and not only crypto, right? You now have things like NFTs and these other sort of amorphous digital assets written to the blockchain that are going to be even harder, I think, both to value and to determine whether or not, they're prudent to hold these. You're going to need, if you have NFTs, you're going to need experts to value these things. If you're a fiduciary, same with crypto, you might need to bring in experts both to value and to help you understand how to manage it, hold it, trade it. I think it's really important, if you're dealing with these assets, and I think everybody will, I think it's inevitable that you'll have a trust or estate that owns cryptocurrency or NFTs, to engage the appropriate experts legally as well as on the technology side, because there's certainly, risk in holding it as an investment and in valuing it and managing it both from a technology and a fiduciary standpoint. So it's a exciting and somewhat risk-fraught frontier that we're going to see a lot of it. And I think we should all find a nice book on the blockchain and encryption and get a little bit of understanding about how these assets work and how we might value them and manage them, because it's going to be part of our future.
Thank you, Kevin. I think I recall seeing an article just recently where a gentleman, I think maybe in Scotland, was an early investor in Bitcoin, and he had the encryption key on a hard drive, which he inadvertently threw away. And apparently, there's like $1 billion worth of cryptocurrency in a landfill, and he's petitioning the local landfill to be able to dig it up and find that hard drive. But to your point, if you lose it, it's gone, and so you really have to be very careful about marshaling it. But thank you, I appreciate it.
So there's a joke that I just heard that you used to have your in your home safe, right? You used to have your gun and kind of your wallet or whatever. Now you're gonna have your gun and a hard drive, a flash drive that has your cryptocurrency key on it, so that everybody knows where to find that.
Yeah. Well, it definitely raises some fiduciary issues, and obviously safeguarding that is really important. Thank you. I appreciate you sharing that. And we're going to now shift to Christine Piersall, who chairs our private client fiduciary services practice group, and she's going to be talking about planning with retirement assets. So Christine, turn things over to you.
Thanks, Farhad. So I'm going to take us back to December 2019, where COVID was just a mere whisper. And at the Fiduciary Focus back in February of 2020, I did a presentation on the Secure Act, and then the world shut down. And then now it's all starting to come back to normal, and planning with retirement assets has become more of a forefront. You know, in 2020, the CARES Act came out. There was no required minimum distributions. Not only did the world shut down, the IRS pretty much shut down, and nobody went to work to make it even slower than it normally is. And, you know, there was some guidance, there were some questions about the Secure Act. Like, so what the Secure Act did was it took away your stretch IRA. It used to be that if you left, if you had a designated beneficiary for your retirement account, they could stretch out the payments over their lifetime. That was great for parents to leave assets to their children. They could then start taking distributions after the parent died and stretch it out over their life expectancy. The Secure Act got away with that, got a 10-year rule for anybody other than an eligible designated beneficiary. There's also been a little bit of confusion with the IRS. Initially, they said, you don't have to take required minimum distributions after someone dies, so you can just hold it till year 10 and take everything out till year 10. Then they said, wait a minute, you're going to need required minimum distributions. And recently they said, okay, required minimum distributions are required if the account holder had reached the distribution age. So, you know, I mean, it's still hard to get a little bit of guidance. But there's still a lot of planning that needs to go into account. You know, we've been talking about a lot of really, really unique assets, but a lot of us have retirement accounts. A lot of us, and that's the whole point of it, is that we have, you know, Congress wants us to save, and they have these great vehicles to let us have money into these accounts. They grow tax-free. We pull them out, we have to pay taxes on it, and it's a big revenue generator for the IRS. So that's why the Secure Act came, so that we couldn't continue to defer. And like I said, most of us have it, most of our clients have it, and it's something that needs to be looked at in the plan. So eligible designated beneficiaries. So some of our clients have these individuals that they want as a beneficiary that in looking at the plan, you might want to leave these assets, retirement assets, to these eligible designated beneficiaries versus, you know, other like children. And these eligible designated beneficiaries are surviving spouses, disabled individuals, chronically ill individuals, children who have not reached the age of majority, which is 18 in Virginia, and individual beneficiaries who are not more than 10 years younger than an account owner. So if there's a sibling, or maybe you're in a position where, you know, you don't, like a girlfriend, boyfriend, those type of things, and you want to provide for them, this is a really good, and there's a large or a retirement account or 401k, this is something that you can provide for them that will enable that person to continue to get to stretch out with their life expectancy. You know, they still have the rules for surviving spouses. So if an individual has a spouse, so you've got a married couple, I typically will just have the benefit, and it's, you know, sweetheart wills almost that we have the retirement account just go directly to the surviving spouse. That way you can just do a rollover. If there are issues or the tax planning, or maybe second, third marriages where we have a marital trust, you could still do a marital trust. Just make sure that it is a conduit trust. A straight up marital trust where the spouse gets all the income is not going to qualify as an eligible designated beneficiary when you're talking. So it has to actually be a conduit trust where not only where you basically, and to qualify for the Q-tip deduction also, is you have to have all the net income, and anything that is distributed out of the retirement plan has to go to the eligible designated beneficiary. So, you know, you want to go ahead and check those, because a lot of people may have designated the marital trust as the primary beneficiary, but may not have the requisite conduit trust provisions in there, and it's not going to qualify. And then you end up not having to be able to stretch, and you're going to end up with the 10-year rule. For disabled individuals, typically you're not going to give a disabled individual an outright distribution. There are special needs trusts, although you might have a disabled individual who isn't mentally disabled that you don't need a supplemental But a lot of times if they're receiving benefits, you have a supplemental needs trust. Again, just that if you've got children and one has a supplemental needs trust, this might be an opportunity to leave the retirement assets to that child versus the other children to have the continued tax deferral. Same with chronically ill individuals. Sometimes you might want to also leave it to children or grandchildren. Sometimes I have grandparents that want to leave stuff to the grandchildren. So if you've got somebody under the age of 18, and so during the age of minority, you have very small required minimum distributions because it's based on their age. So it's a very little bit amount of money that has to be taken out for until they turn 18. The issue is if you want to be able to hold it longer than age 28, then this is not a good planning technique. But if it's a smaller amount, I have grandparents who want to leave just a little bit of something to their grandkids. This is, and the money will continue to grow. And this way sort of forces it to grow. This is not a bad idea to have to fund bequests to grandchildren with retirement accounts. And then, as I had stated before, individual beneficiaries who are not more than 10 years younger, that always helps too. Situations where siblings, you want to take care of siblings, maybe rather than other assets where, you get a step up in basis. You can go ahead and distribute the retirement accounts to these individuals or create conduit trust if you want them to have the benefit of it during their lifetimes. But if at their death, if there's any money left, you want it to go to the children. There's also, with the Secure Act, and anything even before the Secure Act, charitable beneficiaries. If you've got a client or that is charitably inclined, I've always said, let's look at your retirement accounts first for funding and fund it out of your retirement accounts first. Because $10,000 to a charity is $10,000 to a charity. $10,000 to your child is not $10,000. It's $10,000 less the taxes that they have to pay out. So I've been working with a lot of clients and going through beneficiary designations and designating the charities. The trickiest part about that is sometimes they have a specific amount in mind and not necessarily, percentage of their retirement account. And it's sort of hard to tell because your retirement account today versus 10 years is either going to, it's not going to be the same value. So a lot of times, if they have an amount in mind, we can make up provisions in their trust that reduces the amount that they receive from other, we basically reduce the amount the charity receives from other assets as a result of the death of the account owner. If you also have a charitably inclined beneficiary of the client, maybe a charitable remainder trust. So you can leave it to charitable remainder trust where there's no taxes upon receipt of the amount. There will be taxation over life of the beneficiary. So that does defer some of the taxes, which is what the stretch IRA let us do, and the Secure Act took away. But again, with the charities, you have to have somebody that's obviously charitable inclined. You're giving up, you're saving the tax dollars, but you're giving up 100% of the value. But I have a lot of clients that are charitably inclined and then they've got nice retirement accounts, and I've got some who have taxable estates, and I said, let's just designate your charities and put them in your IRA, and it's a great technique for them, and especially in light of the restrictions and pulling out and the Secure Act making us having to pull out monies faster than we had typically done in the past. And with
thank you, Christine. Yeah, appreciate it. That's wonderful. I saw, I think late yesterday, it's always the curse of doing a presentation that the IRS issued proposed regulations on the new requirements. They're 275 pages, so I'm going to get a big cup of coffee on Saturday morning and start pouring through those. Don't really look forward to it. What's that?
I was able to read the blurb about it.
Yeah.
That was the required minimum distributions after the age. Like that's where they switched it. But yeah, I have not read did not get up this morning and read the 275.
Yeah. it's always the curse of doing a presentation that the IRS drops some regs on that. But from what I've seen, they're not terribly significant departures, but they've certainly changed the formatting, and obviously we'll need to deal with the changes that the Secure Act provides. But it's been a long time coming. I mean, you had something that was passed in end of 2019, and they're just getting around to the regulations. But to your point, it's been a lot of these COVID delays. We have maybe a few minutes for some questions. Any questions that you might want to go over? We had a couple in the chat. One person wrote in and made, I think, a really good point that that not all states recognize the qualified small business stock exemption. So while you may be able to exclude the $10 million of gain for federal tax purposes, it may not be available for state law purposes. And you noted that California does not recognize that QSBS exemption. I'm curious, I'm going to put Jenny on the spot. Do you know if Virginia recognizes that? Are you aware if they do or they don't?
They do. Virginia is a conformity state for qualified small business stock.
Okay.
There are, I will say, for OZ purposes, there are a few states that don't accept the OZ deferral. So you do have to keep that in mind for state planning, that you may not get that deferral from a state perspective.
Okay. Well, that's great. Any other questions? Let's see. All right, we're going to take about a 5-minute break, and we'll start back probably right around maybe a 7-minute break. We'll start back at 11 o'clock. So thank you very much.
Welcome back, everyone, to our 13th Annual Fiduciary Focus program. In this last segment of our program, Farhad and I will be discussing the topic of irrevocable trusts. Is it truly irrevocable? How to modify or terminate an irrevocable trust. When we hear the word irrevocable, what usually comes to mind? Unchangeable, unalterable, cast in stone, not possible to revoke. Well, as a result of numerous legal mechanisms that have evolved over the past couple of decades, such as reformations, mergers and divisions, non-judicial settlement agreements, decanting, the word and term irrevocable has taken on a counterintuitive meaning in the estate planning world. Irrevocable trusts are often required to achieve a client's tax objectives. However, trusts don't always work as intended or as our clients wish for them to work. So in many cases, it's necessary to modify or change the terms of trust to more accurately reflect the settlor's intent, changes in beneficiaries' needs and other unanticipated circumstances, or to address changes in tax law. Next slide, please. There's several reasons for modification. Those reasons could be administrative reasons, perhaps changing where the trust is administered, or the law that governs the administration of the trust. To provide for resignation, removal, and appointment of a trustee without court approval. Trustee compensation can be another reason to modify a trust, again, without having to go back for court approval. Changes in beneficiaries' needs and other unanticipated changes of circumstances can include perhaps transferring assets of a trust to a special needs trust for a disabled beneficiary, adding a power of appointment, dividing a single pot trust into separate trusts for each branch of the family. Next slide, please. Tax reasons for a modification, perhaps converting a trust to a grantor trust or to non-grantor trust. Also, division of trusts for GST or marital deduction planning purposes. And finally, changes to correct errors or address ambiguities in the trust instrument would be another reason that modification to a trust may be necessary. Next slide, please. The Uniform Trust Code is a model for states to use to provide a uniform, comprehensive, easily accessible guide to state law questions. Next slide. We're gonna have our first polling question for this segment. How many states have adopted the Uniform Trust Code? We've got ranges everywhere. We'll give a few more seconds here for a few more answers. Okay, it looks like polling is slowed down. So the answer is, as of January, this past January, when Hawaii adopted the Uniform Trust Code, we've got 35 states and the District of Columbia that have adopted the Uniform Trust Code. Next slide, please. This shows several of the states that have adopted. The Uniform Trust Code was completed in 2000. It's been amended several times since. Virginia's Uniform Trust Code contains judicial and non-judicial trust modification and termination mechanisms that follow the model trust law of the Uniform Trust Code. One note here is that the Uniform Trust Code does not have a decanting provision. Many states, however, including Virginia, have adopted statutes authorizing decanting. And Farhad, a little later in the segment, will be discussing the decanting trust mechanism. Next slide, please. Okay, one mechanism for modifying trusts is, and a very popular one, non-judicial settlement agreements. And under this mechanism, all interested persons may enter into a binding agreement that without court approval with respect to any trust matter, so long as that agreement does not violate a material purpose of the trust and includes terms and conditions that a court could approve. Interested persons is defined to mean those persons whose consent would be required in order to achieve the settlement if it were to be approved by the court. Several matters can be resolved by non-judicial settlement agreement, including the interpretation or construction of the terms of the trust, direction to a trustee to refrain from performing a particular act or granting the trustee a necessary or desirable power, resignation or appointment of a trustee, determination of the trustee's compensation, and again, transferring the trust administration to a different situs. Any interested person may also request the court to approve a non-judicial settlement agreement in order to determine and ensure that the representation provided was adequate, and to determine whether the agreement contains terms and conditions that the court could have properly approved. Next slide, please. Modification or termination by consent is the next mechanism. Now this, depending on the jurisdiction, this may or may not require court approval. Under Virginia law, a court is required to approve. Upon petition to the court, if the settlor and all the beneficiaries consent to modify or terminate a non-charitable irrevocable trust, even if that modification or termination is inconsistent with the material purpose of the trust, the court will enter an order granting the modification or termination. Similarly, if we don't have the settlor's consent, but we have all of the beneficiaries consenting, and again, a petition to the court is made, the beneficiaries can terminate a non-charitable irrevocable trust, so long as the court concludes that the continuance of the trust is not necessary to achieve any material purposes of the trust. Again, consent of all the beneficiaries in a non-charitable irrevocable trust can be used to modify a trust, as long as the court concludes that the modification is not inconsistent with the material purpose. Even if the consent of all beneficiaries is not possible, a proposed modification or termination can still be approved by the court, so long as the court is satisfied that all of the beneficiaries, had they consented, a modification termination would be approved under this section, and ensuring that the interests of all beneficiaries who didn't consent was adequately protected. Next slide, please. Modification or termination due to unanticipated circumstances. A court can modify the administrative or dispositive terms of a trust or terminate a trust If, because of circumstances not anticipated by the settlor, modification or termination will further the purposes of the trust. The modification must be made in accordance with the settlor's probable intention to the extent possible. In Virginia, modification or termination of an uneconomic trust. If a trust in Virginia contains assets with a total value of $100,000 or less, so that the value of the trust is insufficient to justify the cost of continuing to administer the trust, the trustee, after notifying all the qualified beneficiaries of the trust, can terminate the trust. Qualified beneficiaries is defined in the code as any distributee or permissible distributee of trust income or principal. Next slide, please. Reformation to correct mistakes. Even if unambiguous, the court can reform a trust to conform the terms to the settlor's intent, as long as it's proved by clear and convincing evidence that the settlor's intention was and that the terms of the trust were affected by mistake of fact or law. And that can be proved whether it's expressed on the face of the document itself or induced from other circumstances. Court can also modify the terms of the trust in a manner that's not contrary to the settlor's probable intention in order to achieve the settlor's tax objectives. The court can provide that this modification is retroactive. One note here is that whether modification made by the court under this section will be respected under federal law is a matter of federal law. So absent some specific statutory or regulatory authority, the IRS has normally only respected modifications that occur prior to the event that would give rise to the federal tax event, meaning such as the death of the settlor. Specific modifications that have been authorized either by the Internal Revenue Code or the service include modifications of a trust for a non-citizen spouse so that the trust becomes eligible as a qualified domestic trust, and the splitting of a trust, to better utilize the GST transfer tax exemption. Another mechanism for modifying a trust is dividing a single trust into two or more separate trusts, or combining two or more trusts into a single trust. And the trustee can do this after notice to all qualified beneficiaries, so long as the division or the merger does not impair the rights of any beneficiary or adversely affect achievement of the purposes of the trust. This section is very helpful from an administrative economy if the terms of the trust combined are substantially identical, because then the combination can cause a reduction in trustees' fees, the ability to file one as opposed to multiple income tax returns. So there's a possibility here to save from an administrative economic standpoint. However, because this section allows a trustee to combine those trusts, even though the terms are not identical, the more the dispositive provisions of the trust to be combined differ from each other, the more likely the combination will impair some beneficiaries' interests, and then less likely the combination would be approved. Next slide, please. Well, regardless of whether a trust modification or termination is pursued by judicial or non-judicial means, proper representation is required of all parties involved in the dispute. The most common forms of representation in terms of who may represent and bind another is representation by fiduciaries and parents and virtual representation. In both, to the extent that there's no conflict of interest, the person, the representative, the person representing, and the person being represented can include a trustee who can represent and bind the beneficiaries of the trust, a parent who can represent and bind their minor and unborn child, as long as a guardian or conservator has not been appointed. And in terms of virtual representation, again, unless there's some conflict of interest, a minor, incapacitated, unborn individual, or a person whose identity or location is unknown and not reasonably ascertainable may be represented and bound by another having a substantially identical interest in the proceeding. One note here in terms of fiduciaries and trustees' duties liability, especially in the case of non-judicial trust modifications, ensuring that informed consents are obtained from all parties and that representations, in fact, has been adequate will provide some extra degree of protection for a trustee participating in the modification or termination. Okay, I think that's it. And I'm going to turn it over to Farhad to discuss the decanting portion of the segment.
Great. Thank you, Tammy. That was a terrific review of the trust modification under the UTC. I'm going to shift gears and talk about the decanting statute and the concept of decanting. When we think of decanting in the context of wine, the idea is that you're taking an old bottle of wine, pouring the wine out of this old bottle, leaving behind the sediment, and putting it into a decanter. The act of decanting does really two things. One, it leaves behind the sediment, the stuff you don't like, and by actually pouring it from one into the other, it adds oxygen, breathes new life into the wine. And that's really the concept of decanting. Is what you're doing is you're transferring assets from one trust to another trust, leaving behind the things that you don't like and maybe breathing new life into the document. There is sort of the common law roots for decanting go back to a case from Florida, the Phipps versus Palm Beach Trust Company case from 1940. And the idea is that in that case, the trustee had the absolute power to distribute income and principal to or among a class of beneficiaries. And the idea is that if the trustee could give the assets directly to the beneficiaries, so outright to the beneficiaries, the theory is they could do something less than that. And rather than giving it directly to the beneficiaries, they could put it into another trust for the benefit of those beneficiaries. And the case in question was the beneficiary of the trust was relying on the income from that trust and was concerned that if he passed away, his spouse would lose that income. And so he requested that the trustees decant the trust, move the assets to a new trust that gave him a power of appointment that he could appoint the assets to a trust for his wife's benefit. The case went to the Florida Supreme Court. Court said, yes, that is permitted. And the site basically says the power to create an estate in fee, that is to distribute the assets outright, includes the power to create or appoint any estate less than a fee, which is to put the assets in further trust. And there have been a number of cases that in other jurisdictions, in Iowa, New Jersey with the Wiedenmeyer case, and the Morse v. Kraft out of Massachusetts. The Kraft in that is Robert Kraft, the owner of the Patriots. And they've all inferred that there is a common law right of decanting for a trustee to do this. And that is helpful, and I'll come back to that later on in the presentation. If we go to the next slide, I'll also note that there are states that have adopted decanting statutes. As Tammy mentioned, there is a Uniform Trust Decanting Act. Virginia is one of the states that has adopted it, as has North Carolina. And then there are other states that actually have their own decanting statutes. New York was the first to enact their decanting statute, followed by Alaska and Delaware, and it's gone on. Virginia actually adopted, I think it was maybe the 14th or 15th state to adopt its own decanting statute. And then when the Uniform Trust Decanting Act came out, we really restated our decanting statute to bring it in line with the Uniform Act. If you go to the next slide, the general approach under the Uniform Trust Decanting Act is to, it's a bifurcated approach. And when I say that, and going back to the Phipps case, really the idea behind decanting is if the trustee has the power to distribute income or principal for any purpose, then they can do as much of that is, or something less than that. And so you look where you have expanded discretion, that is the trustee has the ability to distribute income or principal for any purpose. You look at the decanting statute under the expanded discretion approach, and there's fairly broad ability to make modifications to a trust. If the trust does not have expanded discretion, it says basically the trustee can only make distributions for subject to an ascertainable standard, the ability to make distributions for support, health, education, and maintenance, then the trustee is much more limited in the amount of changes that they can make. That basically you have to grant to the beneficiaries essentially the same beneficial interests, the aggregate beneficial interests that are substantially similar. If a person has a vested interest, that interest cannot be abridged or eliminated by the decanting. And a lot of states, frankly, that don't necessarily follow the Uniform Trust Decanting Act, still use this bifurcated approach where you can do really broad things if you can distribute for any purpose, whereas you're a lot more hemmed in if you're subject to an ascertainable standard. If we go to the next slide, in order to effect a decanting, there has to be 60 days notice to the beneficiaries. It needs to be given to the settlor if they're living, qualified beneficiaries, each holder of a presently exercisable power of appointment, each person who's entitled to remove and replace the trustee, the other trustees under the first trust, the second trust, and if a charitable interest is implicated, the Attorney General is also included. There is the ability to waive the notice period. So, if everyone's in agreement, they can waive that 60-day notice requirement. Go to the next slide. There is the ability for a person during that 60-day period to object to the decanting and assert that the decanting, there is an abuse of discretion. The Act also provides that if the failure to give notice does not render the decanting invalid, if the fiduciary acted with reasonable care to comply with the Act. If we go to the next slide. And there's also protections that if the fiduciary relied on a prior decanting, that they are protected for having done that. And there's some exoneration for that. Next slide. So one of the things, and going back once again to the Phipps case, the question is, can you add a power of appointment, which is really kind of the backdoor way of adding a beneficiary. When the Phipps trust was created, the child's spouse was not really considered a beneficiary, but if you can add a power of appointment, then you potentially have the ability to add new beneficiaries. Under this bifurcated approach, where you have expanded discretion, you can continue a power of appointment, you can eliminate a power of appointment, you can create or modify a power of appointment, which could potentially add new beneficiaries to that trust. In a limited discretion type decanting, where the trustee can only make distributions for support, health, education, maintenance, then really the beneficial interests in the aggregate have to be similar. If there is a power of appointment, it needs to be continued, and you likely can't add a power of appointment that would expand the class of beneficiaries. So you're somewhat limited there. If we go to the next slide. So one of the things that happens is, in a limited discretion trust, it typically says that you are making distributions for the beneficiary's support, health, maintenance, education. And really what happens, we'll talk about, is in a situation where you might want to create a special needs trust. That's a trust where the trustee has very broad discretion. And so you're kind of swimming upstream, where you're actually going from having a distribution subject to an ascertainable standard and broadening that, where the trustee can make distributions for this disabled beneficiary for any purpose or no purpose at all, and the trustee really can't be compelled to make distributions. That's what you're trying to do. Under the Uniform Trust Decanting Act, there is the ability to do this, and even if you had limited discretion, it carves out and recognizes that you would want to be able to create a purely discretionary trust for special needs trust purposes, and so in that instance, there is a carve out for that type of change. If we go to the next slide, One of the question is, what are the proper objects of the of the decanting? Do you have to consider all of the remainder beneficiaries? Can you exclude a beneficiary? Do you have to include all of the current beneficiaries? And certainly in the case of a purely under the the unlimited discretion, broad discretion, I think you have the ability, if the trustee can distribute to all of my children, any one of my children as much of the income or principal, the trustee could theoretically, I'm not saying they would want to do it, but they could theoretically appoint all the assets to my daughter, and that would be to the exclusion of her two brothers, and that would be okay. Now, the trustee may, certainly get sued by my sons, but it is a proper exercise, at least under the unlimited discretion standard. But in the situation where the trustee is subject to, the limited standard, then I think, they would not be able to, make that type of decanting. So, and then I think you also have to think about the remainder beneficiaries. For example, in that instance, if are the remainder beneficiaries, can those be changed? So, you can include a new beneficiary. You probably can include a new presumptive remainder beneficiary, because you're going contrary to the intent of the settlor. And so I think that decanting is an incredibly powerful mechanism. I was speaking with some IRS folks when decanting, first really came out, and they were issuing some notices about it. And we sort of came to the conclusion that it's sort of like, you're placing a loaded revolver on the dresser filled with a bunch of 5-year-olds. I mean, it's incredibly powerful. It's incredibly dangerous. The thing that I like about the Uniform Trust Decanting Act is it puts a lot of safeguards in there. And so, in the hands of a bad actor, there are a lot of protections that prevent, interest from being changed to a beneficiary's detriment. And I think that's a positive thing. If we go to the next slide. There are a number of tax protections that are included in the statute. You cannot decant in a way that would eliminate or jeopardize the marital or charitable tax deductions. There are protections for annual exclusion type gifts. And so if a person has the right to withdraw contributions and there's a continuing right, let's say a hanging crummy power, that power would continue. You can't reduce or eliminate income interests or alter annuity or unit trust interests. There is the ability to convert a grantor trust to a non-grantor trust, and I've done that. You have to provide notice to the grantor that, hey, you're going to start getting this tax bill, and they have an opportunity to object to that. And there's also protections for or the rule against perpetuities, and I'll talk about this. But what you don't want to do is extend the term of a trust, the vesting period of a trust, or else you may trigger what's known as the Delaware tax trap. If we go to the next slide, as I said, for notice, you should provide notice under the Act. But it's important, I think, for tax purposes that the beneficiaries not consent or participate in the decanting. Now, what we will often do is we will prepare some type of non-judicial settlement agreement that basically says, hey, we're putting you on notice that we're doing this decanting, attached to the documents, and the beneficiaries, acknowledge that notice. But it's important that they not consent, or else they may be considered to have made a gift to the trust. If we go to the next slide, in order to decant, it's done in writing. It should be signed and acknowledged. It needs to be filed with the records of the trust. And as I said, we usually have all the interested parties sign off on that instrument, acknowledging the decanting. Next slide. As I said, if you have powers of withdrawal, you can't decant if the powers of withdrawal are outstanding. You have to retain sufficient property in the old trust to withdraw those, to cover those withdrawal rights. and you need to have sufficient funds sitting available to cover those if needed. And that certainly can come up in the case of, for example, where you have hanging powers where the annual amount is kind of cutting back each year, but there's still an amount that's hanging out there. Next slide. So let's talk a little bit about the tax consequences of decanting, and we'll really look at it from the income tax perspective, the estate and gift tax perspective, and then some GST issues. So the first thing is from an income tax perspective, there really should not be any adverse tax consequence when you sort of terminate a trust and you distribute the assets out of one trust into a second trust. It carries out all of the D&I, all the excess losses and deductions are going to be passed out to the second trust. Typically, the assets just get a carryover basis and attacking of the holding period. And so there really, when you terminate one trust and distribute the assets to the second trust, there really should not be any adverse tax consequence. One question that we get is, are you creating a new trust or is it a continuation of the old trust? And what I will say is that the IRS has been somewhat inconsistent on in their rulings, but their rulings on some of them make sense. Some of the rulings will talk about a decanting where you're changing, let's say, the trustee, appointment and removal provisions, or you're decanting to deal with to add additional fiduciary powers. So you're really just kind of doing a modification of an existing trust. You're not really, it's essentially the same trust. You're just maybe dressing it up a little bit. And in those instances, they said, well, this is really just a continuation of the old trust. So you can continue to use the same EIN. And then there will be situations where, let's say, you're dividing the trust and terminating it and creating three separate trusts for the beneficiaries. That's a situation where it really is you're terminating that trust and you're going to get new EINs. One thing that is a feature in the Virginia statute is that when it talks about a decanting, it talks about a modification or transferring it to a new trust, but also a restatement. And that's an approach that I really like, particularly if you're going to, just have it continue, be a continuation of the old trust. And it makes it clear that really this is just a restatement of the old trust. You don't really need to move the assets, don't need to get a new EIN. And I think it's just a real user-friendly way of doing that. And so we added that to the Virginia statute. If you go to the next slide, one of the things that you need to be careful of is when you're doing a decanting, is there debt in excess of basis? So for example, if you have real estate and you're transferring the assets and there's debt in excess of basis, or it's a LLC interest and there's negative capital counts, if you're transferring, let's say, from one non-grantor trust to another non-grantor trust, you're really transferring it potentially to a new taxpayer, and that may trigger gain under the Crane case under the Supreme Court or under Section 1001. And so you need to be careful. If you're transferring it from an existing grantor trust to another grantor trust, it's a continuation of the same taxpayer. There's also concern under the cottage savings case, which really talked about the exchange. Is the old trust, is the new trust materially different from the old trust? And if that's the case, is that considered an exchange under Section 1001? Are those materially different? And so you have to be careful with that. There's also, as I said, if you convert a grantor trust to a non-grantor trust or vice versa, you have a situation where you potentially trigger gain under the Crane case. There's another case called Madorin, or it's pronounced maybe Madarin, I'm not exactly sure, I call it Madorin, where they basically transferred, they turned off a grantor trust, and the asset had negative capital accounts, debt in excess of basis, and gain was recognized in that situation. So it's something that you need to certainly ask the question, particularly if the underlying assets might be one of these that could trigger this type of gain. If we go to the next slide, from a state and gift tax perspective, generally, the exercise of decanting is a fiduciary power. It's a power that's being exercised by the trustee, not really by the beneficiaries. So typically there will not be any gift because the beneficiaries are not really participating. If the beneficiary is also a trustee, a gift tax consequence could result. The Virginia statute requires in all cases that the trustee be independent, because we wanted to kind of make the statute somewhat bulletproof, that a person couldn't inadvertently, who is a person who's both a beneficiary and a trustee, affected decanting and perhaps trigger some gift tax consequences. As I said earlier, if the beneficiary participates in the decanting, a gift could potentially result. We like to provide that they sort of acknowledge and acquiesce, but not consent to that. I mentioned earlier, there is also the potential possibility of what's triggering what's called the Delaware tax trap. And the idea is that if you have a trust that, let's say, is subject to the common law rule against perpetuity, so lives in being plus 21 years, then that in the old trust, there's, that will be, when that last beneficiary who was living on the date of creation of the trust, when they die 21 years later, those interests must vest. If you decant to a trust that where the interest will vest after the vesting period for the first trust, you will have triggered the Delaware tax trap, and there will be a tax consequence. And so you need to be very careful about not triggering the tax trap. Fortunately, most of the decanting statutes prohibit a decanting and have savings language that basically says you can't decant in a way that extends the vesting period beyond the period of the first trust. And so there's some protections there, but it's something to be mindful of. If we go to the next slide, and then from, really from the GST tax perspective, I think it's important, the reality is very often some of the best trusts that would benefit from decanting are frankly the old trusts. I know, sometimes we'll get a question from a bank trust company and they'll send over a copy of the trust, and it's one that was, it was typed up on a typewriter sometime, in the 40s or 50s. It's been copied 7 times, and so the characters are starting to get a little fuzzy. They've got all these interlineations and notes on it because it's just an old trust. And those are the trusts that often are the best candidates for decanting, because you could add trustee removal, compensation language, additional fiduciary powers, lots of those types of things. The concern, though, is that those, if you modify, these are grandfathered GST trusts. If you modify that type of trust in a way that's not permitted, you lose the grandfathered status, and that's a very, very bad result. Fortunately, there are some safe harbors. There's a discretionary distribution safe harbor that basically says, if you are exercising a power that is a power of decanting that is contained in the trust or available under state law, then that's okay, as long as beneficiary consent or court approval is not required, and the new trust will not postpone the vesting of the interest, and goes back to the Delaware tax trap. And this is the thing I mentioned about FIPS. The question is, you may not have a trust that currently that contains a provision that allows for a decanting. I'm seeing that in trusts that we're drafting today, but a lot of the old trusts don't have decanting language. But for example, if this is a trust that was created after 1940, I have seen attorneys argue, well, the FIPS case really represents the common law of the United States, and so even though we're not in Florida, it does represent the common law, and they've taken the position that you're allowed to decant. I have not done that in that instance, but it is something to think about. And I'll note, I think there's actually a Georgia case that may go back to 1916, so 1916, I think, that actually may provide support that decanting may have existed even earlier than that. So looking to the common law may be an argument. If we go to the next slide, there's also another a trust modification safe harbor that basically says, the modification, the decanting, doesn't shift the beneficial interest, doesn't accelerate the generation skipping tax effect of the trust by shifting the beneficial interest to a beneficiary occupying a lower generation. And once again, it doesn't extend the time of vesting any beneficial interest. And so there are a couple safe harbors. Obviously, when you're modifying, a grandfather GST trust, you want to look at those regulations very carefully. It may make sense to go ahead and seek a private letter ruling, just because the consequences are, for getting it wrong or severe. There are also situations where you have non-grandfathered but GST exempt trusts. These are post-effective date trusts to which people have allocated GST exemption. And I think the same, what the service has said is the same rationale for modification of a grandfather trust would apply to post-effective date GST exempt trusts that have essentially a zero inclusion ratio. So you can sort of analogize those rulings in this context. If we go to the next slide, I want to just kind of go through a few examples, things that we've seen, frankly, over the last year of planning that we're doing with clients and some potential solutions, and whether it's done with decanting or whether it's done with some type of trust modification. I think, as there was a line in one of the earlier slides that Tammy reviewed, that, whether it's a trust modification or you're doing a decanting or you're using a non-judicial settlement agreement, these are all just different paths up the same mountain. You're getting to the same result. You're affecting some modification, and there's just different ways of doing it. In some cases, we'll do a non-judicial settlement agreement. In other cases, we might do a decanting. But I think a couple examples I think will be helpful, just kind of add a little bit of context to this. So first is a situation where you actually add a general power of appointment. We've seen a lot of this, particularly with the expansion of the estate and gift tax exemption to what is this year, $12,060,000. We had a situation where a husband died in 2012. Credit Shelter Trust was funded with essentially $5 million, which was the exemption amount at that time. And lo and behold, the markets have done well. The assets in the Credit Shelter Trust have appreciated to $9 million. The surviving spouse's separate assets are worth $2 million. So the $9 million and the $2 million is $11 million. And that's certainly lower than the spouse's $12 million exemption. And so in this instance, you modify the trust through decanting to give the surviving spouse the formula general power of appointment over the assets in the Credit Shelter Trust. The general power of appointment will cause the assets in the Credit Shelter Trust to be included in the surviving spouse's estate, which will result in those assets getting a step up in basis at her death equal to fair market value. And what that effectively does is take those assets that were had a basis of $5 million and give them a step up in basis to $9 million. So you eliminate $4 million of potential capital gain, and you don't really trigger any additional estate tax. You do it by formula, so you're never going to be in a situation where the surviving spouse will be paying any estate tax. But yeah, I think it's a great planning technique and something that that can work well. If we go to the next slide, another example is a situation that I had just recently. It was a trust with a client. It was moving from Virginia from California. The spouse, there was a predeceased spouse. There was a Credit Shelter Trust that was created, and now the second spouse passed away. And we were looking at there were some GST trusts that were created for the benefit of the children, and we noticed that the trust basically gave the child a testamentary general power of appointment over assets that are not subject to GST tax. So if the assets are not subject to GST tax, you wouldn't want to have a general power of appointment. But it was just the wrong word was used. Should have said that they have the power over the assets that are subject to GST tax. Fortunately, the document had a power for a trust advisor to modify the trust to add or eliminate a general power of appointment. And so we'll just use that power and modify to eliminate that general power. So just a nice way of correcting that error. Another example, the next slide. As I said, is the special needs trust situation. The grandparent created sort of a dynasty trust for the benefit of their children and more remote descendants. The trust provides for distributions for support, health, education, and maintenance. 10 years after the grandparent created this dynasty trust, the child gave birth to a grandchild that has special needs. And the concern is that now, because the trustee can make distributions to provide for the grandchild's support and health, that will render the grandchild ineligible for certain government benefits and programs. And so what we would do is decant a portion of the assets into a special needs trust that doesn't allow the trustee to make distributions subject to an ascertainable standard, but really only make distributions for supplemental benefits or needs for the grandchild. And so that's I think a very elegant way of dealing with that issue. And then at the grandchild's death, those assets would be added back into what I'm going to call the main trust. So a nice way of kind of solving that issue. We go to the next slide. Though I think one of the other things is, just dealing with fiduciary issues. We have a trust that holds lots of business assets. There's an independent trustee who is overseeing those business assets. The family expressed a desire that they wanted really any decision making with respect to these family business assets to be made by the family members and not necessarily by the independent trustee. And so they wanted to basically create sort of a directed trust relationship where the trustee would receive direction by the family members with respect to these assets and really would take advice. Under the trust director statute, the trustee basically receives advice from the trust directors and is really just acting in a sort of a ministerial role, and they just do what they're told. And this was I think a good solution for the family where they wanted to have, the benefits of having an independent trustee and oversee, a lot of the administrative tasks, but the family really wanted to have a voice in terms of what happens to these specific family business assets. And so ended up becoming, I think, a real nice way of handling that. So I think that's the last example. I'm happy to take a few minutes and take some questions if there are any. We'll wait 1 second. If anybody wants to, if there are any questions, they can type them into the chat box or the Q&A box. And if not, we're happy to, feel free to contact any of us and we're happy to respond to your questions. Oh, wait, okay, looks like we've got one question. So the question is, in your example where you added general power of appointment for wife, do the remainder men have to sign off? So the question is, in that instance, I think we would do a decanting, and the remainder men, we would include them as, they would obviously have to get notice. They would not consent to that. It would really be an act of the trustee in doing that, but they would certainly receive notice of the decanting and the addition for that purpose. And frankly, it's in the remainder beneficiaries' benefit, because they're going to get the step up in basis in the assets. I think you would want to craft the general power of appointment very narrowly. So the spouse doesn't appoint the assets to other beneficiaries in a way that might, so I think you can structure it in a way where it's a very narrowly crafted power to ensure that the assets don't go to, new beneficiaries that were not intended. Thank you for asking that question. Let's see, are there any others? Okay, well, I think at this point that concludes today's presentation. We appreciate your participation. As I said, if you have any other questions, feel free to contact us. And anyway, we're really grateful for this. As previously noted, please look for an email from Williams-Mullen by Monday with a link to the presentation slides, as well as information about claiming CTFA, CPE, and CFP credit for this program. And thanks again for joining us today, and stay safe. Bye-bye.